friends, Namaskaram. How are you? Myself is Dr. Jineesh Soni. I am an advocate. In today's class, I will discuss about Section 35, Subclause 3 of BNSS. I will discuss a careful and legal examination of the said scenario so that if you are having any trouble concerning the said protocol, you may easily encounter the problem without getting any further anxiety or panic. So I request all of you to maintain the proper notebook with pen or pencil, and I will specify you both the scenario wherein you will get the notice and the scenario wherein you will not get the notice. So we are directly moving on the board and we are going to start the lecture. Section 35 subclause 3 of BNSS is resembled with section 41A of CrPC. Regarding section 41A of CrPC, we are having judgment of Honorable Supreme Court, that is Arnesh versus State of Bihar. Judgment is pronounced on 2nd of July 2014. In that judgment, Honorable Supreme Court specified three important legal positions. Number one, the arrest should not be done in the mechanical way. Apart from that, reasons are to be recorded, and if the offense is punishable with imprisonment up to 7 years, in that scenario, 41A of CrPC is mandatory. In case notice is not given and there is a detention which is illegal and there is non-compliance, in that scenario, the erring officials of police would be responsible to face departmental action. After that, we are having ample judgments of Honorable Supreme Court and Honorable High Court, wherein it is specified that Section 41A of CrPC is mandatory. Section 35 subclause 3 of BNSS, unlike Section 41A of CrPC, provides immunity from the arrest. Now the important question arises, if we are having 41A of CrPC, then why we are having Section 35 subclause 3 of BNSS on board? The reason is that 41A of CrPC has been repealed because CrPC had been deleted, and since 1st of July 2024 we are having BNSS that governs the investigation, inquiry concerning the criminal matter. The matter could be under BNS or could be under the special law. So basically, Section 35 subclause 3 of BNSS merely says if the police is not requiring any arrest, the notice could be given, and in that scenario, arrest will not be done. But it does not mean that police is having the discretion. The police is bound to serve legal notice, means the notice as per Section 35 subclause 3 of BNSS. And in case notice is given, you are bound to attend the place. Be assured that you will not be arrested, but you have to cooperate. But cooperation does not mean that you are bound to give any evidence that comes with the preview of self-incrimination. That is barred by Honorable Supreme Court verdict. So in step number 1, means in part number A, it is quite clear to us that notice is required to be given by the police, more specifically in the offences punishable with imprisonment up to 7 years. Now we are coming on part number B, what to do in case notice is given. We have to follow the following step. Number 1, acknowledgement. But while giving the acknowledgement, specify date and time. Number 2, expression of willingness, that you are ready and willing to cooperate. Number 3, the declaration policy, which must be that you are not bound to do any confession, and apart from that, you are not bound to disclose any evidence that comes within the preview of self-incrimination. And apart from that, we have to obtain copy of FIR. We have to submit the proper reply. And while making the reply, follow 3 important steps. Deny the allegation, specify why FIR is false, and what is your stand. And in case documents are compressed or concealed by the prosecution, you may apply as per Section 94 of BNSS. Now we are coming on part number C. In case notice is not given, in that scenario, we may serve a notice to the concerned IO with a request to issue notice. Despite of request, there is no notice as per section 35 subclause 3 of BNSS. Then we may apply for anticipatory, or we may approach before Honorable High Court as per section 528 of BNSS. If the process adopted by the concerned police is wrong, it is illegal or indication of overstepping jurisdiction. In that scenario, we may proceed to secure remedy as per law. So basically, in nutshell, we may conclude that if the offence is punishable with imprisonment up to 7 years, the police is bound to serve the notice without any option. In case the notice is not served, we may apply for anticipatory bail, or we may apply before Honorable High Court as per section 528 of BNSS. And in case the notice is given, we are supposed to give the proper reply with specification, so that everything could be on record and we could specify to the concerned authority that the proceedings are abusive process, because everything in the FIR is nothing but abusive process and allegations are bald, concocted, and could not constitute any cause of action against us. So basically, we must give reply to the said notice to parry the further consequences that may usually occasion during the course of interrogation or inquiry on the part of police. So in today's class, I have specified you the importance of section 35 subclause 3 of BNSS, and also I have specified you what you can do in both the scenarios. The scenario wherein a notice has been served to you and the scenario wherein a notice has not been served to you. See you in the next lecture.